needed that qualifying prepositional phrase, but yes, in the last.
Oh,
game.
the last years,
Yeah.
obviously, it's not circle flight.
What?
Oh.
No,
It's
it's
not
not.
Circle
It's
Flight.
not "Go the Distance" from
Oh,
Hercules,
come on.
which is the greatest Disney song.
Okay, who thinks that Zach is right?
What's up?
Lion King, a lot better movie.
Go the Distance from Hercules.
I have, to have only one hand.
Can you sing it?
I don't even know it,
Yes, I
right?
can.
Verse?
What?
Is that the one where they're
Sing the whole
like,
thing if you want it.
stir in the
I
pot?
want it.
Oh, man.
I want a good 2 minutes.
The scary scene.
I have often dreamed of a far-off place where a great
Wow.
warm welcome will be waiting for me.
Amazing.
And the crowds will cheer when they see my face. And the voice keeps saying, "This is where I'm meant to be. I will find my way. I can go the distance. I'll be there someday. If I can be strong, I know every mile will be worth my while. I would go most anywhere to feel like I belong."
Yes!
That was great.
Amazing. All right.
Wow.
That's a huge high five for that.
Useless theater degrees for the win.
Oh my God. I saw Michael Bolton sing that at a Dick Gephardt presidential primary.
What a
campaign.
weird sentence.
Yeah,
Strange sentence. I am currently in a musical where I'm playing a role originated on Broadway by the same guy who sings that in a movie.
Oh,
Roger
right.
Bart.
Oh, I've seen him on Broadway.
In what? Young Frankenstein? That seems
I
like
did
something
see
you
him
would
in
have
Young
seen.
Frankenstein, which was not that good, but I also saw him. You know, I get him confused with Norbert Leopold, but I
Sure.
think that he
That's
was
fair.
in Frog with Robert Downey Jr.
That sounds possible.
Okay.
I don't know that.
All right, we're gonna actually learn some law here. But you should Google. You should later today. You should Google Dick Gephardt and find out just what an ironic juxtaposition it was to have that song sung at a Dick Gephardt rally. He was too boring for Iowa. So let you know. What he was like. It was great. It was great. And then Michael Bolton asked if they wanted to hear another song, the audience, and they were like, no. We're ready for Dick Gephardt.
I've never heard
His
that.
wife's name was Jane. Dick Gephardt's wife's name was Jane.
They were literally.
Dick and Jane.
Oh,
Dick and Jane,
God,
that's
so
funny.
boring.
Okay. All right. We gotta go. We're gonna do housekeeping. We will do practice tip of the day. We'll talk about the issue statements that you did for today, and we'll look at some of those. And we will do a brief, just kind of dip our toe in the water on citations. But don't worry, it's not scary. Nothing to fear. We'll talk about rule explanation. So that is a major part of writing about the law, and we're going to dive into that today. And then we're going to do a garden. And we have a guest speaker, so actually there's no way we'll get to all that. But it's going to be great. It's going to be great. So practice tip, there's housekeeping first. Once you pass your homework to each end, and then actually, you know what? Hold it until we go over the assignment, and then that way you won't have to memorize what you did. And then I'll get it at the end. Can you remind me?
I like yours better than mine.
Let's see. For the next class, I love the readings for the next class. I never assign a reading unless I think it's worth your time. I try to be very selective in terms of not assigning stuff that's useless. So I always like the readings, but these are great readings. There's a reading by Anne Lamott, and I'll email that to you. There's a reading by Judd. The Lamont reading is called Shitty First Drafts, and it's from a book she wrote called Bird by Bird. It's just great. It's great for a million reasons. I won't spoil it. It's awesome. And then the reading by Richard Posner is also terrific. First of all,
I'm just counting people for your
Oh,
attendance.
all
I
right.
just can't see from my angle.
Oh, we got one coming.
Oh, perfect.
okay.
I'm sorry, I didn't mean to.
No, that's all right. At first I thought you were like pretending to play the piano, and I was like,
That's not what I was doing. I was just counting people.
okay, so what was I talking about? Richard Posner. I love this reading for lots of reasons, and I'll go ahead and preview it a little bit. It's a book review. By the way, second book review we've read this year. Anybody remember the first book review we read? Oh, it's killing me. Kill me, Smalls.
The one with David Foster Wallace.
Yes, thank you. It's with written by David Foster Wallace. It's a book review of Brian Garner's dictionary. Same Brian Garner, yours truly, greatest book ever written about legal writing or about anything else. So this is a book review by Richard Posner about the Blue Book. So we've now had a book review of a dictionary. We thought that couldn't be done in an entertaining way. Now we have a book review of a citation manual. But it's terrific because he hates this book. And I also hate this book. But I recognize that you have to learn this book in order to have credibility as an attorney and cite effectively. So we learn it, but before we learn it, we go into it with open eyes about what its flaws are. In part because you should go into everything, thinking critically and not just assuming that because it's assigned to you in a law school class that it's actually right or deserving of more respect than it does. Okay, so, and then on top of that, you should Google Posner too. What's the first thing they're going to Google? Oh, Dick Gephardt. Dick Gephardt, too boring for Iowa. Fourth in a four-man race. And then also Google Richard Posner because he has lost his mind. I don't want to I debate between mocking him when the topic comes up and actually being somewhat sympathetic because it's unclear how much is his fault. But he was a very prolific author and judge and one of the more respected judges for probably 3 generations. He sits in Chicago. And then in the past 5 or so years, he's just gone off the rails and done some unethical things and picked a fight and released a bunch of classified information and self-published a weird book. Anyway, he resigned. Okay, the point is, it's great. It's a great reading. Well, Posner is not great, but the reading is great. And then the Blue Book, 10 to 15, we will start to explore the Blue Book. Yes. And then I'll explain the email in 2 sentences later in class. Okay, so that's the homework. Practice tip of the day. You get 2 practice tips of the day today. So I guess it makes up for Wednesday. First one is short and sweet. Email back quickly, even if just to acknowledge receipt of an email someone sent you. This is another one where I don't always practice what I preach, but I try to. I try to be, especially with students, very responsive. And sometimes you won't have the time in the moment to fully respond to an email. If the email says, please write a 50-page brief, you will not be able to do that day. But it's nice to reply back and say, yes, I will do it, or message received or something like that. And that way the person who sends it just kind of lets them know message was received, creates comfort, makes their job, makes their life a little easier. So email back quickly even if it's just to acknowledge receipt. Practice tip number 2 is a quote that I really like. So I'm going to bring it up. Does anyone know who, I know I'm not going to pronounce this right, but Ta-Nehisi Coates? Anyone know who this guy is?
Oh.
Yeah, why don't you tell me who that is while I pull it up?
Oh, I don't know enough to give an actual academic summary. I know that he wrote the most recent Black Panther comic series.
He writes graphic novels, but he also writes nonfiction. He wrote a book about race that won a bunch of awards. Do any of you have Jamie Abrams for Torch this year?
Yes, sir. All of us.
Okay, so she recommended that book to me. I haven't read it yet, but she said it was one of the best books she's read in the past few years. He also he used to write for The Atlantic. He's written about reparations. He's written about the Trump administration, about the Obama administration. And so he was awarded this thing called a MacArthur Genius Award, which is just the MacArthur Foundation was funny. I'm missing.
I don't know.
Michaela said he needed chapstick.
He needs chapstick. Well, he can afford it because they gave him $1 million to do whatever he wants with this foundation. Just finds people that they think are worth investing in. There are no strings attached. They pretty much just give you $1 million. So
It's a million? That was $500,000.
maybe it's $500,000. You can fact check that. It's good.
Tomato, tomato.
Okay, tomato, tomato.
That's 500,000.
So let's hear what he has to say about writing. It's the second practice tip of the day.
Again. My name is Ta-Nehisi Coates. I'm a writer. Right now I'm a national correspondent for The Atlantic. I have a great interest in how wide the umbrella for reparations for slavery, the relationship between black people and case for reparations. And yet the effects of history protect your body from violence, one to ask questions. Journal, and then to go to bed and wake up. And the challenge of writing the questions I wanted to ask, and then somebody paid me for asking them. And the challenge of writing is to see your horribleness on page, to see your terribleness, and then to go to bed and wake up the next day and take that horribleness and that terribleness and refine it and make it not so terrible and not so horrible. And then to go to bed again and come the next day and refine it a little bit more and make it not so bad. And then go to bed the next day and do it again and then make it maybe average. And then one more time, if you're lucky, maybe you get to good. And if you've done that, that's a success. When I first got the call from the MacArthur Foundation.
Okay, so the writing tip of the day is good writing requires good editing. It will not be the last time you hear that today, and not the last time you hear that this semester, but it's one thing to hear it from me and you think, oh, well, whatever, what does he know? But here we have a bona fide genius, MacArthur Foundation genius, and he's saying the same thing. And also, think of what Coates says when you read Lamott's article, because they're saying the same thing in different ways. That there's nothing wrong with a first draft or a second draft or a 100th draft that's not terrific. The key is to just get up the next day and try to make it better. Okay. All right, questions about housekeeping, practice tips, anything else? All right. So, where's the flashcards go?
Over here. Is that them?
Yep. Jacob, tell us about Smith v. Kane.
It was a case where an inmate was appealing his conviction for murder for five people.
What, just in kind of lay terms, if someone at a bar said, "What's the case about?" What's the legal question? What would you say the legal question is?
Prosecution didn't disclose information.
Okay, so give me a little bit more. Think about what you wrote. Wow.
So popular.
Group text.
Yes, that's him. Okay, so think about the deep issue statement you wrote. You don't have to read it word for word, but I guess to say that it's about information withheld doesn't tell us a lot about the facts. So I guess your first answer gave us some facts, and your second answer gave us a little bit of law. Can you kind of expand a little bit?
All right, so Brady v. Maryland, I go back in the precedent?
Yeah, you can.
Okay. Brady v. Maryland was a case where they ruled that the prosecution must disclose information favorable to the defendant if it's requested. And so the inmate in question, he was convicted for murdering 5 people on the testimony of one witness that put him as the first one to walk into the building. But then later on, they found out from a detective's notes that were not disclosed that that witness made some contrary statements that were never submitted as evidence.
Good. So let me pause there, but then don't forget your train of thought.
Okay.
So Jacob's given us, I think, a good amount of facts in terms of just giving us the basic legal question, and a pretty good amount of law, the basic foundation for Brady. So now bring it home with the question.
So did the prosecution's failure to disclose the detective's notes constitute a Brady violation?
Great. So when you explain a legal question, especially in a deep issue statement, now let's take a step back from Smith v. Kane. Jacob, what are the 2 or 3 things that you really want to have in there? And I kind of just said them already. Let's make it for us.
Facts, law, and question?
Yes. Facts, law, and question is in some ways the application of the law to our facts. So I would suggest that in Smith v. Kane, the law is, the one sentence version of the law that matters most is the 3-part test of Brady. So as Jacob was kind of getting at, the 3-part test requires requires the government to disclose, part 1, evidence that's favorable, part 2, and material, part 3. If they don't do that, it's a due process violation. And then the facts that are relevant, Jacob gave us those 2. You know, this is a murder case where the key witness, the key eyewitness, had told the police, "I didn't see much," and then the defense didn't know that at trial. That evidence made. And so then you apply that in the way that Jacob did. So let's take a look at some answers that you all gave, and also some answers that previous classes gave. Are we here? Okay. All right. Okay, so this was a little on the long side. Anybody remember how many words Brian Garner says aim for as a max?
75?
75. Yeah, so this is more in the 100 range. You know, that 75 is more of a standard than a rule. You know, it's a target. If there's an actual word limit rule in the court's rules, never go over that. Never go over that. And also in class, like if you have a 3-page limit rule, never go over that. What do you think can happen in real practice if you go over a page limit rule or a word count rule?
Don't throw it out.
Yeah, throw it out. Throw it out. I mean, a court with any kind of like humanity behind it will give you a chance to then resubmit your brief. They won't just say like you lose. But they'll throw it out, and it's it's on the docket that your brief was rejected. It's embarrassing, time consuming, and all those things. Okay, so our client wants. Let's go ahead and read this one. Our client wants Smith is convicted of 5 counts of first-degree murder. Facts, important facts. Only one eyewitness identified Smith as one of the shooters, and his was the sole testimony tying our client to the crime. While seeking post-conviction relief, Smith obtained the notes of the lead investigator of the crime, which were withheld from the defense during his trial. More facts. The notes quoted several interviews with the eyewitnesses, all of which stated that he could not describe nor identify any of the gunmen. All facts. Was the withholding this evidence a violation of Smith's rights to due process? So this person has, I think, all the facts that you want. I think this person could have been more concise in summarizing those facts, but I think, good job in not having missing facts. Let's see if this person gets the law in for the briefings. It probably was a due process violation. In Brady v. Maryland, the court held suppression by the prosecution, evidence favorable to the accused upon request violation due process, where the evidence material and the guilt or the punishment. I'm not a huge fan of really long quotes. This quote's not too long. We'll talk later about the perils of long block quotes. But this is just stating in a sentence or less than a sentence what the test is. The evidence withheld directly contradicts, by his own words, the testimony of the only person that tied our client to the crime. I like that. It is very good rule application to facts there. It is very likely the court would find it material. If so, the evidence passes both requirements of the Brady test and is withholding by the prosecution was almost certainly a violation of the client's Fourth Amendment right to due process. So let's take this and compare it. I'm going to have you break into groups of 2. Compare it to this. Neither of them, they're both hopefully good. These are examples of ones that are done well. Hopefully done well. Under Brady, the state violates due process by withholding evidence favorable to defense that is material. So this one starts with the law instead of starting with the fact. I think it can work either way. Evidence is material if there is a reasonable probability, could have changed the trial's outcome. So look what this is doing. First, it has a 1 sentence about the general rule of law, and then it says, okay, I think there's something in that sentence that might be unclear to you, the reader. Curse of knowledge. I know what it means to be material, but maybe you don't know what it means to be material. So let me tell you. evidence and material, if there's a reasonable probability, would have changed the trial's outcome. Okay, now we all know what it means to be material. We all understand all three parts of the Brady test. Why do you think, just take a volunteer, why do you think that the sentence, that the second sentence does not explain in depth the meaning of the other two parts of the Brady test, withheld and favorable? It's what?
It's not relevant to, like, the question was whether or not the information was material.
Yeah, so I actually think I think that's one of two reasons why, one of two reasons for that. The reason you're getting at, I think, is correct. Smith v. Kane really only raises one question. In the three-part Brady test, they agree on two parts, they're just going to debate the third. Then I also think it's really not important to explain what it means to withhold or what it means to be favorable in the question presented, because we all more or less know that already. Now, there are some nuances that you would want to explain in your actual memo when you're doing rule explanation for withholding and for favorable. But at this point, you can kind of count on the reader, curse of knowledge. You know, what does the reader know, what does the reader not know? The reader probably knows what, a general sense of what withheld is, what favorable is. Okay. So in our case, Juan Smith was convicted of murder based only on the eyewitness testimony of Larry Boatner. The state did not disclose that shortly after the murders. Boatner said he could not identify any of the perpetrators. So hopefully this has all the facts that you need, and hopefully did it in a little bit more concise way than the first one. Were those statements material? So a bit of law, a bit of fact, and then we're going to apply it. Yes, because Boatner's testimony is the only reason for Smith's conviction, and is significantly undermined by his contradictory statements. It's reasonably probable that Smith would not have been convicted if the contradictory statements had been disclosed. Therefore, the state violated the Brady rule, and Smith's conviction should be vacated. So talk to the person next to you. What do you like about this? What do you think could be improved? What can you take from this and say, okay, when I write my next deep issue statement, these are things that I want to be sure I have, or you know, there are parts of this that I want to avoid doing. Just take 3 or 4 talk to the person next to you about the deep issue statements we looked at.
I like that they both mentioned why the testimony is important. I think I kind of messed up on that connection. I would say it's yes, a definite yes, probably yes. Because I don't know if you read the dissent, but there was like a lot more language. That one statement, like the guy asked about identification test.
I actually read that and that's what took me so long.
Yeah,
I could have just
that part was so much longer than that video. It's like on Lexus, it was like, this is the opinion, and then like, this was the dissent.
But I did less than I guess I'm still gonna come, but the same thing. So I'm reading all the dissents, and then I get to, like, they don't want to do it. Like, get to the end, I'm like, oh, this kind of persuade me that
It's actually a pretty good idea.
But
So, I mean, I just don't like the definite yes. I feel like they probably just didn't read the dissent. But I guess another thing,
I guess, see, I got confused because you can't already have one, so I guess I could say like yes because they did this in law, but if they're not talking like past tense, I guess you can't.
I guess we were, before like there was an opinion, we were supposed to be writing this or something.
So that's why I said
Probably. Just because I guess there's like a glimmer or like a slight chance of losing or whatever.
I like both. My kids, they both batted over. I don't know about where those statements were material, and also you gotta make that connection. And where those statements were, they violate due process. But you could just say when those statements material.
Just make it a lot shorter a little bit.
I think so. Yeah, I can't. I think my dad.
Okay. Taylor, tell us what you think.
I think that both of them are too long.
Tell us why.
They're long in different ways. I feel like the first one is kind of wordy, and then this one I feel like it could have been, there's like shorter sentences that could be put together.
Give us an example. I don't disagree with you.
Like, perhaps we're talking about like the definition of defense, like they could have did like put like material, comma, a reasonable probability if it would have changed the outcome.
That makes sense. So combine those first two sentences into one, save some words. If we, in the next Garnet game we do, whether it's today or next class, we'll practice that kind of thing. So, great. What else? Other thoughts? Logan, what do you all talk about?
We talked about like the first one better. We thought it was like set up like easier to read.
Okay.
And then also like, but we were saying like the second one, just like the word, like how it's worded is like kind of just it's hard to keep what you're reading in mind with what's actually what the reader or the writer wanted us to get out of it.
Okay, so can you give an example of where?
I was thinking that second one, like the first sentence is like basically the whole paragraph, and you kind of just like keep reading and like waiting for the sentence to end.
Very long
keeps
sentence.
dragging on.
So you could probably cut it, what, like right here?
Yeah, I think they're right there, and then you probably need to like attack the end of it in a different way. I think it kind of just feels too long.
Yeah, so maybe we will make that.
Yeah, I think that would be a better start for it.
Good, good. Okay, let's take a look at some kind of like things that are mistakes every year. So. Okay, so let's take a look at the second one. This is kind of a small thing, but you would be surprised. So Juan Smith, parentheses Smith, right there. What is not ideal?
Which one is that? Where?
I'm doing the second one.
Oh,
you can
sorry.
ignore this one. And I'm just focusing on the very first three words.
So he's gonna refer to him as Smith, but he's just presenting him as Juan Smith, so you know who he is.
Yeah.
I don't know.
But is that necessary?
No.
No. So you see this all the time. Wait till you practice. We'll do this all the time. Like, you know, whatever. Zach Trinkle, parentheses Trinkle. Well, like, obvious. Like, you could just leave that out. You know who you're talking about. If the next sentence refers to Smith, we know that you're referring to Juan Smith. You don't need that parentheses. It's just a waste. It's legalese, and you should avoid it. Let's take a look at this one. Under the Brady rule, a state may not withhold evidence or material from the defense that is favorable to the defendant's guilt or punishment. What's wrong with this?
State not withhold.
I think they just like got the rule wrong.
Yes.
That makes sense. It's
Yeah,
not-
they don't understand what they're talking about. Tell us, explain a little more.
Well, evidence or material, like that's not the way the material is being used at all.
Yes. Yes, in the
Oh.
material in the Brady sense is an adjective that refers to like important, basically. So material evidence means important evidence. This person has not taken the time to actually learn what they're talking about. This is, by the way, it's not a current student. This was previous year, so don't look around and wonder who this is. Zach. Yeah, because this person is using the word material as a noun. It's just like another word for evidence, like material, like stuff. But that's totally wrong. Totally wrong. So don't write things that are inaccurate. Detective notes potentially undermining the sole witness for the prosecution, Mary Bodner, were withheld from the defense. What do you think is not ideal about this sentence? This has some stylistic problems, which is not really why I picked it, but it also has some substantive problems with why I picked it. Yeah,
So this is very minor, but when it says detective notes, like I want to say the detectives notes.
I think that's
Sort of like
it's a little more plain English. We don't usually just like
it's almost like the
talk like
detectives
robots,
note.
kind of, you know.
Like just the beginning.
Yeah. I think on the stylistic front, and an even bigger stylistic problem is the subject of this sentence is really far from the verb. We'll do a Garner section later about how, all else being equal, it's good to have your subject and your verb really close. The subject here is notes, detective notes. The verb is way over here, or withheld. There's all this stuff in the middle, and it just makes it hard for the reader to, like, once they get to the verb, remember what the subject was. So not ideal there. It's also in the passive voice. Sometimes there's a good reason for the passive voice, but this would be so easy to put into the active voice. You could say the prosecution withheld detective notes, blah blah blah, from the defense, blah blah blah. Okay, but there's a substantive issue, and this actually I did in looking at some of your answers before class today that you emailed. This was not a totally uncommon mistake. Anybody see it? What's slightly inaccurate about this sentence? Yeah.
Is it just already saying that they potentially undermined it? The notes did? Like, should you
Undermining solely? Yeah, that's not what I'm getting at. I think this person's being a little cautious by saying potentially undermining instead of just undermining. It pretty clearly undermines him.
Well, yeah.
But I think there's just a more blatant inaccuracy than what Emily was talking about. Yeah, Shelby.
It makes it sound like the prosecution is Larry Boatner. Like
So witness Larry Boatner. I can see that too. The way that they've got it. Yeah, I can see that as being confusing. It's not the sole witness for the prosecution. Here's what the case says. The case says.
There's that lady that died.
Yes. So Boatner was the sole witness to link Smith to the crime. Sole witness to link Smith to the crime. But the prosecution called plenty of other witnesses. And so this sentence, as written, suggests that the prosecution only called one witness. So just be careful in terms of accuracy. Let's take a look at this one. Juan Smith pled guilty to 5 counts of first-degree murder on July 1st, 2004. So there's not a substantive problem here. There's a stylistic writing choice problem. I think what it might be. Bailey, if you had to, Elizabeth.
Did he plead guilty on July 1st, or did he do the murders on July 1st?
5 counts of first-degree murder. I think he pled guilty on July 1st, which is how I read it. I can see if maybe there's a little bit of ambiguity with this was written. If you want to be crystal clear on that and you're writing it, what's an easy solution? On July 1st, 2004, comma, Juan Smith pled guilty to 5 counts of first-degree murder. That way we know it's referring to when he pled guilty. The date is just unimportant. It doesn't matter whether he pled guilty on July 1st or July 2nd. There's this great song in You're Good Man, Charlie Brown. Zach and Price sing it.
But whatever it is, it's not a great song.
I love this song.
Musical.
I don't love the musical, but I love the song. And the character, I think, is Sally, sings a song about her philosophy, and one of her philosophies is, why are you telling me? All these people in the world are always like telling me stuff. She's like, I don't care. Why are you telling me? And anyway,
I mean, if you're gonna pick one.
Well, to be continued. We'll start the next class with that, just for you.
Oh, great.
Why are you telling me that he pled guilty on July 1st, 2004? I don't care. It doesn't affect the Brady analysis at all. At most, you should say July 2004. That's still a waste of space. 2004. Okay, we're heading in the right direction here. I don't think it really matters whether it's 2004 or 2005 or 2003. We're not talking about a statute of limitations legal question where it's like, was something done at a certain date? No, just all we care is that he pled guilty to these murders. Oh, and by the way, there's a substantive problem here. Huge substantive problem.
There's no Brady. There's no mention of anything.
No, well, this is not the only part of the thing. We were talking about. I saw Kelsey's hand.
Don't have a trial.
Appeal?
Kelsey's got it. What is it?
He didn't plead.
He didn't plead guilty. They went to trial. Like, he pleaded not guilty. So it's 100% wrong. unclear if there would even be a Brady violation if he had pled guilty, and Boatner wouldn't have been a witness because there wouldn't have been a trial. So it's a really big mistake. All right, let's take a look at this last one. The evidence is material in the sense that it would reduce the potential for the defendant's sentence or likely cause the proceeding to have a different outcome. Material in the sense that it would reduce the potential for the defendant's sentence. I'll just tell you what the problem is here. It's hard to figure out what the person's talking about. I mean, I kind of get the sense because we've all read Smith v. Kane and we kind of know, we have a sense of like what material means now. But if you were doing cursory knowledge and you were just coming to this without any kind of background in Brady law, I don't know, reduce the potential for the defendant's sentence, I don't even think that's a thing. So some room for improvements. Let's pass them out now.
Now I want to rewrite it. It's all we're doing is for the memo. Now you know. Yeah. Do we got some more? Oh.
Okay, so we're going to take 5 minutes max and just kind of preview your reading for the Blue Book. Because, and here's why I'm not just saying like read it and then we'll talk about next class. I want you to see that even though there are like 10,000 words in this book, what we will do in this class is not rocket science. There will be challenging things we do in this class that are not related to the Blue Book, but this is not. This is all doable. It's new and there's a steep learning curve, but I assure you, you can do this. Okay? So here's a description of the case, and let's just look at some ways to cite it if we were going to cite this case. Okay? The case is United States of America versus Eddie Wayne Robertson. It was reported in volume 872, bless you, of the Federal Reporter second series, beginning on page 58. You're interested in material on page 61. It was decided by the U.S. Court of Appeals for the Fifth Circuit in 1989. And so let's unpack like what this means, and then how you describe it in this site. United States of America versus Eddie Wayne Robertson. Okay, one party, other party. Could be Smith v. Kane. Could be Marbury v. Madison. Okay? Cases have one party and then the other party. Case reported in volume 872 of the Federal Reporter second series. So Federal Reporter second series it's a book, just like the Encyclopedia Britannica would be like a book with multiple volumes. This particular book has 1,000 volumes, and we're talking about 872. So if you actually went to the library and you looked on the shelf, there would be 800 volumes, more, 1,000 volumes of Federal Reporter second series, and you would just look, okay, volume 872, that's the one I'm going to. And then if you opened it to page 58, that would be what you're looking at. I mention this because you're going to mainly be looking at cases on Lexis, but you should know what these numbers mean, even though you won't actually be seeing the 872nd volume of a book. Okay? You're interested in material on page 61, so the case start on page 58, interested in material on page 61. Why are we going to put that in the site? Because some of these cases are 100 pages long. And so if you just cite to the case and say, well, it begins on page 58, dear reader, knock yourself out, that's not a nice thing to do to the reader. It's not showing empathy, but also there's a good chance the reader's not going to find the page that you want them to find. So you're going to direct the reader to the particular page of the case. And then it was decided by, as you know by now, there are lots of these courts in the United States, some are federal. It'd be nice to tell the reader which court actually made this for all the reasons we've been talking about hierarchy of authorities and persuasive and controlling and things like that, and the date, 1989. Note that it doesn't say July 17th, 1989, because who cares? It doesn't really matter that it happened on July 17th. We're not going to put that in our citation. Okay, so if this were the first time we mentioned this case, here's how we would cite it. This is what your reading is about, but I'm going to summarize it for you. So first thing you do is you list the first party. This will always be the plaintiff if it's a civil suit, or the government if it's a criminal suit. Slight exception if you're dealing with a court that has discretion on whether to take the case. But just put it in. Okay? United States v. Robertson. You don't list of America and you don't list Eddie Wayne. Just United States, not U.S., not United States of America, not USA, United States, and not Eddie Wayne Robertson. if there's 4 parties, let's say the United States sued Eddie Wayne Robertson and Martha Robertson and Zach Trinkle and Justin Walker, you just do the first person named. So that case would still be called United States v. Robertson. And then you just tell the reader, okay, if you want to go to the library, here's where you find it. You find it in the 872nd volume of the Federal Reporter Second Series, and this is the abbreviation for that. How do you know what the abbreviations are? I'm going to tell you. We're going to practice this message. You don't have to memorize it. It starts on page 58, and I want to direct your attention to page 61. Just so you know, the court that decided it was the Fifth Circuit. How do you know how to abbreviate U.S. Court of Appeals for the Fifth Circuit? I'm going to show you how to do that too. I'm going to give you a PDF. It's going to have all the abbreviations. You won't have to memorize it. In the year 1989. Don't forget the period at the end. Citations always end with a period at the end. Okay, actually, but if you have 3 citations, then after the 3rd citation, it ends with a period at the end. Okay, so let's, there's Emily. Let's just walk through. Let's say that it is a case of Zach Trinkle v. Justin Walker, and it's reported at volume 123, Federal Reporter Second Series, beginning on page 456, and you want to direct my attention to 457, and it was decided by the U.S. Court of Appeals for the Fourth Circuit in 1992. I'll repeat it as we go, but let's do it on the board together, okay? So remember, it's Zach Trinkle v. Justin Walker. How are we going to name the case?
Trinkle v. Walker.
Exactly. And do we want to put it in bold? We want to put it in all caps? What do we want to do? Italics. Since I can't italicize the word, I'm going to do underline, but you would italicize when you're typing. The comma, not italicized. The sky will not fall if you italicize it, but it will be wrong. Don't italicize it. Okay? What do you say? Okay. Okay, so I said that it was at volume 123 of the Federal Reporter Second Series, beginning on page 456. Let's stop there. What should I write for my citation?
123 at period 2D.
Yep.
You said 456?
Yep.
456.
And punctuation mark?
Comma.
Okay. And then I want to direct the reader's attention to page 457, so what do I do?
You put 457.
I'm running out of space, so I'm going to come back over here. And I told you it was in the Fourth Circuit and decided in 1992, so what should I write?
Parentheses.
Yep.
And then 4 CIR dot, or period,
Yep.
1992.
Great.
And then put close parentheses, and then a period.
And the period. Emily, do not forget the period. Great. A couple of things to keep an eye out, frequent mistakes. Microsoft Word will want to make this superscript, the TH. Don't do that. That's not the way it's formatted. And Lexis will want to tell you what state it comes from. So if this were a Virginia case arising in the Fourth Circuit, it would want you to put Virginia in here, but you shouldn't. That's not a correct Blue Book citation. Yeah.
Do you ever indent these citations or no?
So the way it would work when you're writing it, the short answer is no, but you would be like, quote, the plaintiff is great, defendant not so much, read, quote, and then that's a quote from the case, quote, space, and then just type it along that line. Here. Yes, Emily.
I just had a question, 'cause you said that we'll use LexisNexis a lot in practice, I assume.
Yep.
So when we're directing people to a book, is that kind of, like, are people actually gonna go to a book, or is it
No.
just when you go to LexisNexis?
Great question, great question. So let's actually look at how this would how this does direct them on where to go on LexisNexis. So let's go ahead. I wasn't going to do this, but since Emily asked,
Sorry.
I think it's great. Okay? So if we went to Lexis, LexisNexis.com, Lexis Advance, pulls this up. You told them that this was part of the site for United States v. Robertson. You told them that it was volume 872 of the Federal Reporter's Second Series, beginning on page 58. And so you just type that into Lexis Advance, and you press enter. Let's see if this is actually a real case, if I made it up. I made it up. But it takes you to what's actually on page 56 of the 872nd volume of the Federal Reporter, Hines v. Brown, report, all of this. And then let's remember we want to direct their attention to page 61, which doesn't include this case. Let's say we want to direct their attention to page 59. When they're reading Lexis and they're like, okay, well, where's page 59? Because it's all one computer page. They just go to where it says asterisk 59. From there through there, where it goes to page 60. That's page 59. Yeah.
So on the court and the year, we don't have to put that underneath. We can just let it flow into, like, say we still have room.
Yeah, I didn't mean to.
I was
That's a good
just
question,
wondering.
'cause I don't want to, like, it's confusing enough without me adding confusion. So let me just write a little smaller. Okay, so Fourth Circuit.
Yes, sir.
That's
Okay.
how it works. That's how it works.
This makes sense. Thank you.
Okay. All right, I said 5 minutes. Let's stop there. There's more to how to do short versions of it, but we'll get to that. We have a whole semester to glory in. All right, rule explanation. You read some of this in Judy Fisher for today. Let's bring it down. One part of there, so I have 3 statements up here. And to a degree, they tell you what you will be describing in the memo. They tell you the facts, they tell you the legal rule, and they apply that legal rule to the facts. Smith is 15 years old. Person under 18 cannot legally enter contracts. I'm not saying it's the actual contract law, by the way, I'm just making this up. Person under 18 cannot legally enter contracts. Smith could not legally enter into a contract because he was 15 years old. So, which part of that is just pure facts? No law is involved at all. We're Sydney. Sydney just. Yep, Smith is 15 years old. We don't know anything about the law yet. We just know a simple fact. Smith was born 15 years ago. Okay? McKellar. Smith could not legally enter into a contract because he was 15 years old. There's a little bit of facts in there. He was 15 years old. There's a little bit of a legal rule in there. Who can and can't enter into a legal contract. So it's not rule explanation. You remember what it's called?
Is that the analysis?
Yep, rule analysis or rule application. And that just means we take a legal rule and we apply it to specific facts. Now, a person under 18 cannot legally enter into contracts. There's nothing in there about the facts of our case. That sentence would apply whether we're talking about 15-year-old Smith, or 25-year-old Wilson, or, doesn't matter what. That's just a statement of the legal rule. So that is rule explanation. A person under 18 cannot legally enter contracts. If it's more complicated than that, then we would start with that statement and we would explain it and explain it and explain it. But 3 parts to a memo, 3 parts to legal analysis, 3 parts to when you write a brief. Right? It's going to be the same, regardless of the format. You're going to have some facts, you're going to have some law, and you're going to apply the law to the facts. Today we're going to talk about how to explain the law. Later, another class will talk about how to apply that law to our text. Okay, so. Explanation versus application, we just talked about that. Chronology. I just said this too. First you state the rule, and then you prove it. It's kind of like, anybody know the motto of Missouri? Like the Garden State or the Keystone State, but it's not. It's called the Show Me State. It's like, I don't trust you, you have to show me. I don't believe you, you have to prove it. So that's how rule explanation works. First, you can state the rule, all right, terrific. But then prove it, show me. Use text and cases and other authorities to explain, elaborate, prove that that rule is the rule. And when you do that, don't use block quotes. Why do you think, as a general matter, and there are exceptions to every rule, but as a general matter, block quotes are evil? Any volunteers? Emily?
It's not really your writing, and you're just kind of regurgitating what someone else has done or said.
That is true. That's descriptively true. But can someone else explain, like, take what Emily said and explain why that's not just a description of the block quote, but why it's bad? Why it makes the reader's job, yeah.
You're mixing like two different styles of writing and just throwing them into each other?
To a degree, it can be like jarring for the reader. Kelsey.
Could it be like the Chris of knowledge thing?
Explain that a little more.
So like, if you're using a block quote, it could be written in a way that the reader might not understand, so it's your job to know.
Yeah, I think Zach and Kelsey are both kind of getting at, there's a decent chance that block quote is not written as well as it could be for your purposes. So I think everything, Emily, Zach, Kelsey, all have good thoughts on this. Let me read, this is kind of a long explanation, but this is from an actual judge giving his reason why attorneys should not use block quotes. All right, I love this quote, and before you ask, I'm aware of the irony that I'm reading a block quote about why you should not use block quotes. So, okay, I'm guilty as charged. My hypocrisy knows no bounds. You know what movie that's from?
I don't.
I just like to, just make me feel better about myself to occasionally know something that doesn't. It's rare, but.
Clarify, only in pop culture.
Yes.
Is that a debate?
Okay, here we go. So very often, this is the judge speaking, people will find a great quote and they will put it in. They'll let the quote do the work. Sometimes it's a big block quote. And they think to themselves, oh, this is just so good. I've got this big block quote. But you know what? This is the judge speaking. I don't read block quotes. I skip over them. To me, it's just yada, 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 yada. If there's something good in there, I expect the lawyer to tell me what it is. So the bigger the block quote, the less I'm likely to find what you're looking for. Sure, if you've got 3 words in a quote that are really on point, that will really help in a sentence you construct, going back to what Zach's talking about, and you build, and you highlight those 3 words in a way that will be meaningful and great. But to just say, here's a quote, ta-da, it's foolish. It just means the lawyer was lazy. It's fine, he says. There's no problem writing it. You can write it all you want. You can even send it to your mother. She'll be impressed. She'll say, ooh, look at that. He writes just like a lawyer. But don't send it to me. I already know you're a lawyer. What I expect you to do is go through and pull that stuff and make a judgment about the things that work, the things that will persuade, versus the things that are just yabba, 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 yabba. You know what happens when I see yabba, yabba, yabba? It's not like I see it and wait for the next thing to come up. No, my mind goes and I start thinking about something else. I start thinking about another case, or my gardening, or my chickens. Or I start thinking about going snowboarding in a couple weeks, and there I am snowboarding down a mountain in Aspen, and pretty soon I've forgotten about your case. And next time you see a block quote, just like think to yourself, like we don't always do this, but we do this sometimes. Just like we're reading along and we get the block quote, like, okay, I can skip this. If there's something in that block quote that's important, pull it out and use it, and don't just have this general block quote. Okay, so when we're doing rule explanation, here's what we've covered so far: what it is, state the rule and then prove it, Don't use block quotes to do it. And then here's really the most important structural, organizational thing. Start with the general and move toward the specific. Start with the general and move toward the specific. What does that mean? Zach, what do you think it means?
Like as far as quoting?
No, just in terms of rule explanation. I'm going to explain to the reader what this legal rule is.
Start with the general rule and then apply it to your case afterwards.
Well, we're not doing application yet. We're just explaining the rule. But you're right. In a sense, CREAC is starting with the general and then moving toward the specific. The general is the rule, and then the specific is how you apply that rule to our facts. But even within explaining the rule, what does it mean to start with the general and then get more specific? You can phone a friend.
Yeah, phone a friend.
Just dying to explain. Yeah.
If you
Shelby.
start with like the general, the big picture rule, and then you start to like break it down into like simpler things to understand.
Exactly. And one way to think of this is don't make it a mystery. Don't make it a mystery. Don't give me a little fact here, a little part of the rule here, and a little part of the rule here, and then only at the end give the big reveal about what the rule is. No, do the opposite. Reveal the general rule right at the beginning, and then get more and more specific in explaining what that is. So let's not speak in the abstract. Let's actually give an example of this. So this will probably take us about to our next speaker. So here's an example of, starting with the general and then getting more specific. Let's say that you have the task of explaining actually one of the more complicated rules that you'll probably study in the next 2 years. And that is the general rule for race-conscious diversity programs at a university. What is the rule? We're not going to apply that to specific facts of our case. But imagine that you are a lawyer for a university and you're defending your policy, and you're writing a brief or you're writing a motion. You have to explain, okay, here's the rule. Here's the general rule before we get to our case. Okay. Start general and then get more specific. So I'll walk through this. What's the most general thing you could say? Just the text of the statute itself. Or in this case, the 14th Amendment of the Constitution. 14th Amendment includes the Equal Protection Clause. You might quote it, quote, equal protection under law. Okay? So that's the most general thing. We are all entitled to equal protection. That doesn't tell us a lot of specifics, but it does just give us, okay, that's the most general we can state this. Now, get a little bit more specific here, but still we're still awfully broad, right? The Equal Protection Clause generally prohibits race-based classification. So as a general matter, a university cannot use race in terms of classifying people. It's a general matter. But let's explain this rule at a narrower level. But some race-based classifications are constitutional if. So now we've stated the very general rule as a general matter, no race-based classifications. But there is an exception to that, and now I'm going to explain that exception. Some race-based classifications are constitutional if they are narrowly tailored to serve a compelling government interest. So now we've stated the general rule and we stated the exception to the rule, but we still have a lot of work to do, right? Because this exception is not just self-defining. You walk up to someone on the street and say, hey, let me tell you about something that's narrowly tailored and it has a compelling government interest. They're not necessarily going to know what you're talking about, right? So let's provide a general definition of both of those phrases. Right? The government must have a truly significant reason for discriminating, that's the compelling interest, and it must show that it cannot achieve its objective through any less discriminatory alternative. That's narrowly tailored. Right? So now we have a general sense about what each of the two prongs of the exception to the general rule are. But I should still suspect that if you're reading this, you're still not like entirely clear about, okay, what can a university do? What can a university not do? I now know the general definition of narrowly tailored and compelling government interest, but I'm just still not sure what that means in practice. So now we're going to explain the rule at a much narrower level, and we're going to take it piece by piece. And if you were writing a memo, this is exactly what you would do. I mean, I have it in outline form, but you would just be doing this in paragraph form, drilling further and further down. So you say to the reader, and you wouldn't actually use these words, but let me explain to you what I mean by a compelling government interest. Let me explain to you what I mean by, look up there, a truly significant reason. And by the way, Chemerinsky, which is the main constitutional law treatise, uses the word discriminating. I don't actually think discriminating is a great word for what's going on. I think truly significant reason for using race as a factor. Because discriminating has a negative connotation and I think a more neutral connotation. In any event. So what does it mean to have a compelling government interest? What does it mean to have a truly significant reason for discriminating? Well, let me tell you, let me show you, maybe Missouri style. Here's what it looked like in some previous cases. And so if you were writing a memo, you would just kind of walk through what it looked like in each of these 3 previous cases. Compelling government interest. The educational benefits that flow from student diversity are a compelling government interest. The court has said that in the Cal Davis case, in the Michigan case, in the University of Texas case. So here's what compelling government interest looks like, and here's what it doesn't look like. The court said in the Cal Davis case, a classification that aids persons perceived as members of relatively victimized groups at the expense of others who have not discriminated is not a compelling government interest. So you can't use a program to remedy past wrongs. You can use a program to increase student diversity. I'm not here to say whether that's good or bad or whether the law is correct as it's evolved. I'm just, if you're explaining the rule to somebody in a memo, this is what you would say. Compelling government interest is a truly significant reason for doing something. What is a truly significant reason? Improving student body diversity. That is a truly significant reason. If that's the government's goal, then their goal is an okay goal to pursue. So are you with me so far? Not necessarily in like all the nuances of this area of law, but just how we're starting general and we're getting more and more specific. So specific that we're now talking about what the specific program at Cal Davis looked like, what the specific program at Michigan, and the specific program at the University of Texas looked like. So now we've explained what it is and what it isn't. But we've only explained the compelling government interest. We haven't explained what it means for something to be narrowly tailored. So you do the same moves here. Now that I've explained compelling government interest, I'm now going to explain narrow tailoring. And I'm going to do it at a very narrow level. That's probably like not the ideal word choice by me there. At a very specific level. Okay? Here's what narrow tailoring looked like at the University of Texas. The court found that that program was narrowly tailored. And here's what non-narrow tailoring looked like at Michigan College. So now after the reader sees this, they don't just have a general and kind of abstract definition of what these words mean. They can actually see examples of this was narrowly tailored, this was not narrowly tailored. Right? So that is kind of the name of the game in rule explanation. Give a general explanation and then use some concrete examples to illustrate abstract concepts. And you saw this, by the way, when have we seen this before? In memos that we've read. Alex.
In the Barger book at the one that was gone. And then I guess the emailed one you sent me too, but that was more of a broader one.
Yeah, but the Barger memo that I emailed and the Garner memo at the back of the book both do rule explanation. They both state a general abstract principle, and then they use examples from the past to illustrate that principle. And then once that author is done with that process, you have an idea, some sense, okay, well here's what the rule is. And only then do you say, okay, I'm gonna take that rule and apply it to my facts. And by the way, let's say that we are representing the university in this matter. When we get to rule application, here's a little preview. What are you gonna do? You're gonna say our facts are like the facts in Cal Davis, and Michigan Law, and the University of Texas. And our facts are unlike the facts in Michigan undergrad that were invalidated. You want to say, here's how you do rule application. You compare the cases that came out the way you wanted them to come out to your facts. And you take the cases that came out the wrong way, and you say how your facts and our case are different. That's rule application. We'll get to rule application. All right. Specific, after the general. General to specific. And the Garner memo that Alex mentioned, really good example of how this is done. I think the Barber memo is a pretty good example too. Okay. Questions? Okay. So we do have time for. So take, go to Garner section 5. Go to Garner section 5 and do basic number 5. Do yourself first, and then share your answer. I think it's the odds that go to the board today. So the odds that go to the board.
Nah, we're even. We're 6. Yeah.
I'm just keeping track of it because I would not know.
Basic number 5 is the one on page 26.
So we're just taking out needless words?
Yep. Delete at least 4 consecutive words. Replace those words with just one word. You may rephrase the rest, but don't change the meaning. Which one do you think is best? I will take, if there's no volunteer, I will take a Soviet one. Priya, you're in an even group, right?
Yeah.
All right.
I'm sorry. 3.
You don't have to apologize for their mediocrity.
Well, they just, okay, at the beginning, it says the court examined a number of cases. You didn't really have to say that. They said the court stated that there are a limited number of cases, which is good, concise way to say the first half of that. They took out there would exist, which was just not necessary, so that was good.
And my guess is, I think it would be hard for even group number 1 or group number 5 to say that there's substance in there's important substance that's missing from group number 3, and so we could just count the words.
Yeah.
I think there's probably in the range, I was kind of doing it a little while you talked in the range of 35 or so words here. 3, 6, 9, 12, 18, 21, 24. This is in the range of 27 or so words here. So they've saved, I'm going to guess this saves in the range of 5 to 10 words from there and there.
I also took out only, but no one did that, so I don't know if I.
Say that there are only a limited. I think you could take out only, yeah. What's the difference between saying there are only a limited number of instances and there are a limited number of instances? Although actually I could see where maybe the point here is to emphasize that this limited number is not a lot. Whereas maybe if you took out only, it might give the impression that you were trying to say, hey, it's really important that there are, at least a limited number of instances. I can see maybe only being useful there. Are you going to defend yourself, Phil?
Oh, I was just going to say more about only, actually. That would make more sense, actually, if you, because only sounds like more of a justification term. So if you said that with the court examined a number of cases, then it sounds like only would justify that. Or then examining the cases would actually justify the use of only, but I'm not sure.
So you're saying it's good to have it in there?
In that particular sentence, no, because it doesn't have a number of cases. But I'm not sure.
I think you're saying, but in that one, yes. But in this one, it would make sense.
Right.
Group number 3, what do you think? No. Tell us why. Then we're going to get to Buddy.
Well, I think only is just emphasizing how there are a limited number.
Limited number of instances. Yeah, I think if you go back to the original, part of the substance of the original that matters is the original is emphasizing that these instances are limited. They're not a huge number. And so I see a reason to have it in both. But, perhaps reasonable people can disagree. I'm gonna, let's talk after class. Let's vote, even groups, who votes for group number 3? Obviously, plus 50 for group number 3. Bill didn't even do the right one. Okay, so it's my great pleasure to introduce our guest speaker today. Buddy Cutler has spent a lifetime providing counsel and representation to many of the people who make our lives more convenient and healthier and safer, like nurses and firefighters and UPS pilots. A Louisville native with a bachelor's degree from Yale, we'll forgive him for that, Buddy fell in love with labor law at Cornell Law School. Since then, he has become a leading legal advocate of labor unions. He's a senior partner at Pretty Cutler, Naka & Mead. Did I pronounce Naka right?
You did.
Only 4 years, I finally got it. He recently argued a landmark case at the Kentucky Supreme Court challenging a law that prohibits employers from requiring workers to financially support a union. Its supporters call it a right to work law, but I suspect Buddy would call it a right to work for less law, or a right to free ride law, or something along the lines. You can't say right to work law. Please welcome Buddy Cutler.
Thank you, Justin. I learned something just from your